Hey there, I'm Christine and this is the Freedom Update. Today I want to tell you about a new case heading to court this fall in Ontario. It's a legal challenge to Canada's voting system. A coalition of advocacy groups is arguing that Canada's voting system, a system called First Past the Post, is unconstitutional, even though this is the voting system that we've had in place since Confederation. The Canadian Constitution Foundation will be intervening in this case to say that while our system may not be perfect, it is perfectly constitutional. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you would be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember nothing in my videos is ever legal advice. If you have your own legal question or problem, consult your own lawyer. So let me tell you about this new case challenging our voting system. If you think back about 8 years, you may remember when he was just a candidate for prime minister, Justin Trudeau famously promised that, to quote him, "As prime minister, I'll make sure that 2015 will be the last election under First Past the Post." Well, there may be some mounting uncertainty about when the next federal election will be, but there is one thing for sure. Whenever it is, it's going to be under First Past the Post. First Past the Post, for those of you who don't know this term, it is the electoral system that Canada inherited from the United Kingdom. It's shared by many other Commonwealth and British influenced countries like India, the United States, about a dozen Caribbean countries, and 18 African nations. In First Past the Post systems, the winning candidate is just the one who has the most votes. Winners don't need a majority of votes, they just need more votes for anyone else. And the term First Past the Post comes from horse racing, where there's a post at the end of the track and the first horse to pass it is the winner. So Trudeau's 2015 promise to end First Past the Post, quite obviously, it was not kept, and it didn't even make its way into the next Liberal platform in 2021. But it is a regular feature in the NDP and Green Party platforms, probably because it's in their interest to have a change to the system. First Past the Post disadvantages smaller parties whose vote is less what we call efficient. In other words, they have broader national support, but they don't have concentrated support in specific ridings. Their support is more diffuse. So just a really brief commentary about this promise from 2015. I think it seems very transparent that the 2015 promise by Trudeau to change the system was just intended to entice those NDP and Green voters to vote for Liberal this time around in 2015 so that Trudeau could win and form government under the First Past the Post system. Now, whether or not the promise was genuine, if he ever intended to keep it, we will never have any idea, but we do know that very, very little effort actually went into implementing the promise, and it was not made again in the next election. Moving away from First Past the Post, as I said, would advantage parties like the NDP, the People's Party of Canada, and the Green Party, and that change would be at the expense of the larger and more regional parties like the Bloc Québécois and the Liberals and Conservatives. But since First Past the Post actually makes it very much less likely that these smaller parties will gain power, they have not been able to implement their preferred electoral system, and the government of Trudeau obviously didn't keep the promise. So then we get to the courts. Some advocacy organizations have turned to the courts bringing legal challenges to try to force the issue. Two organizations that are bringing the challenge in Ontario are called the Springtide Collective and another organization called Fair Voting BC. And they have moved forward with this constitutional challenge to Canada's First Past the Post system, which is going to be heard by the Ontario Superior Court in September. These advocacy groups argue, that the first past the post system violates the charter, and it violates it in two ways. First, the Section 3 right to vote and the Section 15 guarantee of equality. The thrust of their argument is that first past the post undermines the right to effective representation guaranteed under Section 3 of the Charter because it does not give citizens equal voting power, since votes for losing candidates are, they say, wasted. You'll be familiar with this phenomenon if you vote for your local MP during an election and you vote for the losing candidate. Your vote didn't actually contribute to who formed the government. The advocacy groups are also arguing that the first past the post system violates the charter guarantee to equality because it discriminates, they say, against women and minorities by contributing to their underrepresentation. Now, from my perspective, whether or not first past the post is politically unfair is just not an issue that should be decided by the courts. It is a pure policy question. Sure, the first past the post system has its flaws, but so does every other electoral system. The applicants in this case, these advocacy organizations, have a preferred system, and it's called proportionate representation. And that system has been adopted by some countries around the world, and yet no democratic utopia exists on this planet. For example, Israel has a closed list proportional representation system, but it remains notoriously factionalized, and it faces frequent elections due to unstable coalitions. I'd be interested in your perspective on whether you would prefer, as a policy option, first past the post, the system we have now, or some other system like proportionate representation, which is being advocated for in this case. Both systems have their pluses and minuses. For example, a benefit of proportionate representation is that votes don't get wasted. You contribute to the election of a member of the party you prefer and who you voted for. But a downside of proportionate representation is that it can empower fringe and extreme parties and result in factionalism and a coalition government that needs to pander to extremes. It also lacks a geographical grounding, and for some people, local connection to government really matters a lot. They want to be able to elect a local member of parliament. First past the post has those benefits of geographic grounding as well as the benefits of simplicity and stability, but it does mean that your vote may not end up contributing towards the election of your member of parliament or the formation of government. So there are upsides and downsides to the different systems. But for me, this is a policy choice. This is not a matter for the courts. Canada's first past the post system is perfectly constitutional. The Constitution Act 1867 includes provisions that establish a constituency-based federal electoral system. And under first past the post, every constituency in the House of Commons is represented by a single member. And it is uncontested that this system has been virtually unchanged since Confederation. The Charter cannot displace these prior constitutional provisions in the Constitution Act 1867 that permit this first past the post system. And the Supreme Court of Canada has held in multiple cases that the Charter was not intended to abrogate the provisions of the Constitution Act 1867. In fact, when the Charter was enacted, it expressly preserved, with a few exceptions, the foundations of Canada's existing constitutional order, and Section 53 of the Constitution Act 1982 states that unless expressly repealed, existing constitutional statutes shall remain as law in Canada. There's also a presumption that laws and practices that were constitutional as of 1982, when the Constitution was patriated, and that includes first past the post, they remain constitutional. The patriation of the Constitution didn't sacrifice everything that came before it on the altar of constitutional progress. Rather, it marked a reaffirmation of the legal tenets and commitments that animated Canada's original settlement. The Charter wasn't intended to upend all or even most of what came before it. So we have made all of these arguments, and on this point, the advocacy groups challenging first past the post bring up this famous living tree metaphor. This notion that the Constitution is a living tree capable of growth and must be read in a broad and progressive manner in order to adapt to changing values. This is a very famous metaphor you may have heard of before. It was first used in a case at the Judicial Committee of the Privy Council in a ruling in 1929 called Edwards in Canada. It's also famously known as the Persons case. And this quote about a living tree is frequently misunderstood. While our Constitution can be fairly conceptualized as a living tree, the growth of this tree is constrained within its natural limits. And that natural limits is a quote from that same decision that somehow these progressive advocates often just drop off. They forget to say that there are natural limits to this growth of the living tree. The Charter is not some empty vessel to be filled with whatever meaning we might wish to put in it from time to time. And the Federal Court of Appeal recently articulated that constitutional interpretation isn't just based on some vague feel or spirit or vibe. The Charter is constrained by the language, structure, history, traditions, and the underlying philosophies of our society. Its interpretation is a rigorous, objective, and disciplined judicial task guided by the words of the Constitution itself and viewed in light of their historical context, the larger objects, and, where applicable, meaning and purpose of the constitutional provisions. Our system of voting, first past the post, is not perfect. No electoral system is. But the system can't be ousted by the Charter through vague inference or implication. It's up to Parliament to decide if the system should be changed. Simply put, first past the post remains constitutional because nothing in the Constitution expressly says otherwise. And that is what we are going to be saying as an intervener in the case this fall. If you want to stay up to date about this case and all our other cases, you can subscribe to our email freedom updates at theccf.ca/freedom updates. And of course, you can subscribe to this channel so you can catch my next video update about the case. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.